Good stuff. Well, good afternoon, everybody. It's 1 o'clock. We might as well get started right on time. Our guest has a lot of great information to talk about, and so we don't want to cut Dominic Cardam short. My name is Neil Kalin. I am an advisor to the Real Property Section Executive Committee. Joining me as guest host today is Tom Lombardi, who is also a executive committee member for the Real Property Section, and we're going to be interviewing Dominic Cardam from the Ventura County District Attorney's Office. And we're going to get to Dominic shortly, but hello, Dominic. Just say hello to our audience, please.
Hey, good afternoon, everybody. Thanks for having me.
You're quite welcome. We've got some interesting cases to discuss today, and let's see, as always, we want to just start off with something a little bit light, let you know what's going on. Here's our agenda for the next hour. We're gonna talk about what's going on with What's Up With Us. It's a new year. You see, we've got some new hosts. Last meeting, September, was the last regular session for my co-host for the last 2 years, which was Ashley Peterson. She's taking on a lot of other responsibilities and cannot be a regular co-host this year. So we'll talk about in just a minute what's going on. We're going to start off talking about Amy's Kitchen versus Fireman's Fund. Another in what seems to be a growing list of cases arising out of insurance and COVID-19 and what's covered and what's not. Then we'll have our interview. We will end up with 2 more cases in Ray Hawkeye, something that I have to tell you, I know absolutely nothing about. Maybe Tom has a little more knowledge about debtors in possession and bankruptcy law. We'll find out soon enough. And then we're going to end with today's 4 versus LA County Metropolitan Transportation Association, case involving downtown Los Angeles hotel, the Bonaventure Hotel, right near where you used to work for years, Tom. And so we're going to see whether they were successful in an inverse condemnation claim. And we'll end up talking about some activities. And I want Tom to give us a recap, because Tom was a leader in the Crocker Commercial Symposium, which happened a few weeks ago. And if you wouldn't mind, Tom, maybe you'll just give us a short recap about how that went. I know I had other activities going on. I logged in, but I kept logging in and logging off. So I'm going to have to go back sometime since I signed up and paid. So I should be able to listen to those programs at a future date. So that's our agenda for today. Go ahead, Tom.
Oh, I'd be happy to.
Okay. Yeah, we'll get around to that when we get to after we finish our cases. So let's talk about our first case of the day. Oh, before we get to the first case, you're right. So what's going to happen? So you see Ashley will pop in from time to time. Tom is always welcome to join us on What's Up With Us. We're going to have a somewhat regular host, and that's going to be Michael Simkin. And he's going to be doing that on a regular basis. I don't know if he'll be doing it every month. And then we're going to have many mystery guest hosts for this coming California Lawyers Association year, which technically started at the end of September. So here we are. We've got Amy's Kitchen versus Fireman's Fund. And what happened with Amy's Kitchen? Well, let's talk about it for a few minutes. Amy's Kitchen operates facilities in 3 states, really, in the Northwest: California, Oregon, Idaho. What does Amy's Kitchen do? It manufactures organic and vegetarian meals, right? Well, like so many businesses during the pandemic in 2020, Amy's Kitchen was originally ordered, to close down, but then if they wanted to stay in business, they had to meet certain requirements. And what did Amy's Kitchen had to do? Well, they had to get temperature screening equipment, protective shields to separate their workers, masks, goggles, cleaning supplies, right? They paid hero pay. What did Amy's Kitchen do? Because they had a policy that went through either mid 2020 or into the fall of 2020. Can't remember when their policy ended. So they filed a claim, an insurance claim with Fireman's Fund. Amy's had a communicable disease coverage as part of their policy, and they had an extension, and part of the extension said what? Said that firemen's will pay for direct physical loss or damage to the insured property caused by or resulting from a communicable disease event at the location, including the following necessary costs, right? To tear out and replace property that was insured, to repair or rebuild property that was insured. And here's the key issue of this case, or C, to mitigate, contain, remediate, treat, clean, detoxify, disinfect, neutralize, clean up, remove, dispose of, test for, monitor, etc., the communicable disease. So Amy filed a claim, which Fireman's denied. Amy sued for breach of contract, declaratory relief, and bad faith, and Fireman's demurred. And those of you who've been following these cases, matter of fact, we talked about a case, Marina Pacific versus Fireman's, a few months ago on What's Up With Us. You know, hey, the insurers have been pretty successful in avoiding payouts in these COVID-19 claims. And that's the result that Fireman's got at the trial level. The demur was sustained, and the court said, well, trial court said, COVID-19 did not physically alter any insured property. Therefore, there was no direct physical loss, right? Just like the policy said, direct physical loss or damage. Trial court sustained the demur. Amy's Kitchen appealed. The appellate court had a very interesting opinion, I thought. They said, well, when we're looking at the language of the policy, we don't stop by looking at direct physical loss or damage. We have to look at that in the context of the entire sentence. And the sentence has that language, paragraph C, that I've highlighted on your screen. And they said, in interpreting insurance policies, the court's job is to interpret the policy as a reasonable layperson would read the language and what were the reasonable expectations of the insured. And the appellate court went on and it distinguished some of the other cases, saying there had to be some kind of physical loss or damage, and said, you know, many of those cases, those cases were really brought up in the discussion of whether there is income loss coverage as opposed to the type of claim that Amy's Kitchen was making for the cost of the screening equipment, the protective shields, the mask, the goggles, the disinfection, etc. And matter of fact, in one of the cases that was distinguished, Marina Pacific, they said, yes, it happened to be the same policy, it happened to be the same language, but this paragraph C was never an issue in that case. Therefore, it's not controlling on the Amy's Kitchen court. And when the court was looking and said, you know, if all we're dealing with is there some physical loss, is there some physical damage? Well, nothing in C really has to do with physical loss or physical damage. So they're saying C would really be surplusage, and part of our role as a court is to give meaning to the language of the party's contract. So the court says, you know what? We think under this coverage, under this policy, there can be coverage. Amy should have been given an opportunity to amend its complaint. But the court mentioned something else. It says, you know what? In order for this policy to apply, there has to be a communicable disease event at the location, okay? In order for it to be a covered event, it has to be addressing the property specifically and not just some kind of general rule. So firemen's may still come out ahead here unless Amy's able to show, and there was some indication they might be able to show that, but we can't tell for sure from this opinion. But Amy still has a hurdle. They got by one because C applied, but it looks like they're still going to have to go over another hurdle, and I'm sure Fireman's is going to be contesting that, Tom, did you get a chance to look at this case or give us
Yeah,
your
I did, Neil, and it's good to be back with you too. I do miss those days when we were co-chairs of the real property law section, so it's nice to have some banter with you once again. But yeah, I read the case and I found it really interesting too, because it's distinguished from the business interruption line of cases, and insurers were doing really great. And I was really surprised when I read this ruling. There's one section or the holding that I highlighted here, the statement made by the Amy's court, where it says the only plausible interpretation of subparagraph C, which you've highlighted here, of the communicable disease extension in this policy is that the need to clean or disinfect infected or potentially infected covered property constitutes direct physical loss or damage of that property within the meaning of the policy. I mean, that's really significant. So I thought that was something that the court really latched onto, and obviously is what's driving the decision. And it seemed to me too, my conclusion was we're going to see more of this case because anecdotally in the decision, it appeared that Amy's counsel was pointing out some orders that were directly applicable or representative of the court that it could actually amend to satisfy, the requirement that these outstanding health orders are directly applicable to their facility. So if that's the case, we're probably going to see more coming down the pipeline. This would be one to monitor for sure.
one to monitor, and something else, and this is beyond my area of expertise, but seeing that how Amy's Kitchen had some success with the appeal here, I don't know if there's some kind of limit as to when you could bring a policy claim, but it seems like, the insurers have been pretty successful defending against these. And now that there's an opening, if there's still time, if they're not time barred to bring claims, we may see more of these. And that's going to depend on whether there's statute of limitations or whether there's limitations in the policies themselves for when a claim has to be brought.
That's right. And I can imagine, everybody's, if you're a business owner, you're discouraged from all these prior business interruption decisions from really pulling out the policy, engaging counsel, getting a draft complaint in order, filing when you've got such a uphill battle. And then this comes along. But now at this point, when you pull out that policy, the first page you're going to turn to is basically the limitations provisions and how long you've got to actually pursue that claim. And there could be a lot of business owners that are just not going to be in a position to do it.
You're right. And, some business owners, I suspect, may also make just a financial calculation, right? Okay, so they had to get masks, for their staff, right? They had to put out disinfectant, in each of the stations. Is that going to be worth it, right, to bring a claim against their insurer who is going to contest, right? We know the insurers are going to contest it. Is it going to be worth it to hire a lawyer? Is there enough money at stake to make it worthwhile? I think that's going to be another issue. Those who find out that they're not too late are going to have to take that into consideration. Okay, well, thanks, Tom. Thanks for having our discussion. Let's move on now. And let's talk with Dominic for a little bit. And here you see here on the right side of your screen, Dominic is, I love your title, Dominic. So it's extremely impressive, and you look good. I feel kind of ashamed. At least I'm in a button-down shirt today. Tom has his jacket on. Dominic has his jacket and his tie on. So we're going from the lowest level to the highest level. I'm glad you look so professional, and you certainly look like a senior deputy district attorney, Dominic. You know, very, very, very appropriate there. And you're with the real estate fraud unit at the Ventura County DA's office. And we'd like to start off just asking you, tell us a little bit about yourself, your legal background. How did you make your way to the DA office?
Well, thanks for having me. Went to law school. Can you hear me okay, Neil? Tell them
Yes.
everybody we're good. So I went to law school at Pepperdine, graduated in 2003, clerked at the LADA's office. Great experience doing preliminary hearings down there in the Temple, in the courthouse on Temple. Wanted to be a trial attorney, and started with the DA, with the Ventura County DA's office shortly after graduation. You know, took the bar, and have been barred since 2003. And my background includes, you know, similar to other prosecutors. In our office, everyone starts in misdemeanors, and you work your way up through there. So I've worked in domestic violence. I spent a lot of time in narcotics. I should mention, before I started with the DA's office, after I took the bar, I sat for my broker's license. So I have a real estate broker's license through the DRE. So I've always maintained that. Went forward in my career. I was a federal prosecutor for a couple of years down in for US DOJ in San Diego in the Southern District. And then just before I took that position, I just met my wife, and we were dating, and then we decided to come back to Ventura County. So I'm back with the DA. So I currently, thank you for that very glowing introduction. Appreciate that. Currently assigned to real estate fraud. So we're busy, as you can imagine, but isn't everybody, right?
Well, you're right about that, and it's interesting to say you're busy. I imagine, you know, several years ago when there was that big downturn in the market, and we know at that point I worked for the California Association of Realtors, and we saw, you know, a lot of fraud going on when people were selling their homes, and through short sales and after foreclosures, and a lot of instances of representations of people, we can get you out of, you know, the foreclosure, or we can get your property back. But then the market really picked up. And so I imagine a lot of those cases went away. Were they replaced by something else?
Well, yeah, you're mentioning the foreclosure consultant fraud, Civil Code 2945.4. We saw a lot of those cases where people were collecting upfront fees, promising to modify mortgages, and essentially doing nothing. So as the market, as you correctly pointed out, improved, we're not seeing a lot of those types of complaints anymore. And now there is no real typical real estate fraud, you know, case. Everything is different, as you can imagine. But we're starting to see, with the market improved, more of equity stripping, or trying to acquire title to strip someone's equity, or we see investment schemes where, you know, through an investment, the victim is promised a secured lien position in real property, which never materializes, and the money is stolen and laundered. So to answer your question, Neil, with the market still being strong, you know, supply is tight and demand is high, and with values rising, we see more of attempts to steal one's equity, or investment schemes where money is stolen and laundered. And I can touch on some examples and some statutes we typically deal with, if you'd like me to do that.
Yeah, I'd love you to do that. I just have a question first. When you say attempting to steal somebody's equity, so are you getting like fraudulent recordings where somebody says, "Oh, is that's what you?" Okay, so great. Why don't you give us an example about how these cases come about, how the case gets to you, and you know, I think you had a case, sort of a case summary that you thought might be good for our audience to hear about.
Right. Well, with respect to equity skimming, you know, the fraudster will place themselves on title or try and they'll file a forge or a false instrument. So that's PC Penal Code 115. And if the homeowner or the property owner is alerted to that, then they'll file a real estate fraud complaint form with our office. And all of the real estate fraud complaints are screened by an attorney. And then if we determine that there's sufficient evidence to open an investigation, we'll do that. But circling back to equity theft, yeah, typically they will try and get on title and then pull loans or try and fund loans once they're on title and strip the equity. And then, so that's PC 115. Also, if they strip the equity, potentially Penal Code Section 47. And then from there, we'll typically see money laundering that will file. I also, to my earlier point, no case is the same. Every real estate fraud caper is different. We handle cases involving structuring, where we have agents structuring their banking activity on commissions they earn to avoid taxes. And we also have, agents that will forge their client signatures on car forms. Okay, so it kind of runs the gamut. A case example of a filed case, this is all public record information that I can touch on, involves a couple, Leon and Christina Cherniavsky. Leon is a licensed broker under the Cal DRE. And essentially, in that case, Leon and his wife, Christina, solicited a $400,000 investment from the victim with the representation that his investment will be secured by he'd be in a senior lien position recorded against real property. As we typically see, the lien was never recorded, and the funds were instead used to purchase real property in Christina's name with a silent second scheme on a commercial lender, where on the 1003, the loan applicant, of course, didn't disclose that the down payment was entirely borrowed funds. So they took the victim's money, totally not secured, and they used it as a disguised down payment on a condominium. And Leon was the licensed broker on the deal. So after escrow closed, Leon got $16,000 in commission. Once they obtained the cash from the victim through a series of transactions through Wells Fargo Bank and also cryptocurrency, the money was laundered, and they have been charged with 13 felonies, Penal Code Section 47 grand theft with an excessive taking enhancement. They're also charged with the mortgage fraud for the silent second scheme on the commercial lender, and then the 11 counts of money laundering for the subsequent movement of the money after it was stolen. The charges were filed shortly after the victim. He hired an attorney after he was tipped off that he might be the victim of a fraud. He secured a default judgment. Christina and Leon fled to the Ukraine, so they're currently in the Ukraine. Arrest warrants have been issued. There are outstanding arrest warrants for $1 million each for their arrest, and that's an example of, not a typical case. It's somewhat complex, but that touches on investment schemes where false representations are made to secure funds and money's laundered, et cetera.
So Dominic, when you're doing these cases, and I realize what your answer cannot apply across all of the cases that you take, but is it the district attorney's role to try to recover some assets from the perpetrator that could go to the victim, or is that outside the scope of what the DA does? No,
that's within the scope via restitution order. So I should mention, in the case I just covered on the Cherniavskys, during the investigation, our investigators located and froze about $150,000 in cash that was, we believe, stolen funds from the victim. in an account at Wells Fargo, and also in some cryptocurrency accounts. So we have taken steps to freeze those funds, and under 186.11, the aggravated white collar crime enhancement, freeze and seize the money for restitution should a conviction result from the filing. So that's one of our main goals. Oftentimes, by the time we get the case, or by the time a real estate fraud complaint's filed, the money's gone, generally. Okay? But we will take steps to locate and secure assets and freeze them for restitution for the victims. In every case that comes in the door. It doesn't mean we're always able to do that. Typically when the money's stolen, it's laundered and moved rather quickly. But in this case that I covered, on a $400,000 loss, we were able to freeze approximately $150,000. And actually, after we froze his accounts, we got a phone call from someone identifying himself as Leon, wanted to know why his accounts were frozen. He was calling from the Ukraine. He has an attorney. There's been some litigation after the filing with respect to efforts by his attorney to obtain a portion of those funds for legal defense. We've dealt with those motions, and the money is still frozen for restitution.
So Dominic, are you able to engage in that type of activity, the seize and freeze, or vice versa, outside of California, or do you solely focus on finding assets that remain in California?
The latter, assets that we have, that we have the legal ability to freeze for restitution. Okay. It's a good question. I mean, the account at Wells Fargo and the cryptocurrency accounts, this is one of the first times we've gone into cryptocurrency and frozen funds that are in that format. So if we can connect the assets or the funds to the defendant, then we can secure them for restitution. So I think we can cast a pretty wide net, as long as we can make the connection and those funds are under the control of the defendant. They don't necessarily have to be stolen funds, but if they're assets that can be liquidated later for purposes of victim restitution, then we can ask a court to approve that and issue that order.
Okay, so, and you find other courts in the United States are cooperative in that regard if you find assets out of California? Well,
we're dealing with our court only here in Ventura. So okay. Yeah, it's issued solely by our court.
Okay, just by your court. Okay.
Right.
And Tom, I don't know if you have any questions. I have another one, but I'll give you a chance.
Sure. Yeah, no, thanks, Neil. And Dominic, first of all, thank you for all your good work. There has been, in my experience being a real estate litigator, there are many times where we hope to get a DA involved and direct their attention to, to a particular matter that is potentially, involves some criminal aspects to it. So what I find in my experience, number one, is that there is a limitation in resources out there, and I know that that's a challenge that all our prosecutors face. And there is some line that has to be drawn as to where, which matters will be directed attention and which matters are left to the civil arena. And I'm just interested in your, from a DA's perspective, what kind of crosses the line over a civil dispute versus something that really is squarely within the criminal realm of the real estate world. If you could maybe juxtapose some matters that you've looked at, but just we're really, at the end of the day, the conclusion was they were more of a civil issue than a criminal issue.
Well, really, it turns on whether we can prove a specific intent to defraud, whether it kicks it over into the criminal arena, so to speak. So if it's a straight breach of contract where there's no criminal intent, if there's, in say, for example, purchase of real estate, there is, just simply because someone breaks a promise doesn't rise to the level of a crime, right? So it really turns on whether we can show, and if there's evidence of a specific intent to defraud at the time, the deal's made. And so it's very, very fact sensitive, as you would imagine. And, but really can we identify specific intent to defraud? And that's really what we really focus on. Does that help? Or no?
It does. And, one thing that I've also seen in so many matters that I've been involved with litigating is whether or not there is some form of a negligent misrepresentation or whether there was that actual fraudulent intent.
Right.
And, and that's where I've seen some difficulty, because we suspect that there's been fraud, but to establish fraud in the civil arena as a civil litigator, it's just, it's just a more likely than not standard, versus when presented to a law enforcement and a district attorney, it's beyond a reasonable doubt, obviously.
Right.
And what I find is that, in many instances where I'm dealing with fraudulent conduct, the perpetrator is trying to explain it away as a misunderstanding or some sort of neglect, and not, that actual intent that would rise to that level. Although we strongly suspect it and think we could establish it under civil burden of proof. So it's there are many cases we wish we could get, and I know that the resources are very the resources are limited. So it's something that I think is always out there as civil litigators. We got to think about is where, what threshold should we be looking at reaching before we burden the system, the criminal system, with a referral.
Right. Well, I would encourage you, in cases, and the other people, in the meeting today, if depending on where you're practicing, that I know Los Angeles County DA's office has a real estate fraud section. I think most DA's offices do. That to reach out to the attorney. I mean, they should. We always do return phone calls, and we'll screen it. And if there is a criminal intent where we can prove that that there were false representations or false pretenses made, then that could potentially result in an investigation being open and us pursuing criminal charges. But I would encourage you, to contact your local prosecutor, real estate fraud unit, and get their input. You might be surprised.
Well, great question, Tom. I like that, as you say, juxtaposition between the civil burden and the criminal burden. Dominic, you just mentioned something that made me think. Many years ago, on behalf of the Association of Realtors for which I work, I gave a presentation out in Ventura County, and there was actually someone from your office there. And at that time, and I say this is probably going back 10 years ago now, and at that time, Ventura was one of only one or two DA offices in the state that even had a real estate fraud division. But you just mentioned, do you think that most do now?
I know that our neighboring offices, our neighboring counties have real estate fraud units. Every DA in the state, maybe not, but I know that we're funded through a recording fee that is assessed on all real estate documents. I think it's $10 per document, and that funds the personnel in our real estate fraud unit. So under the government code. So I would imagine that most DAs are taking advantage of that. I know, like I mentioned, Los Angeles, Orange County, San Diego, they have dedicated prosecutors to handle real estate fraud.
Well, I think that's good for our listeners to know. We appreciate you joining us, Dominic. Up on the screen, we've got your address and we got a phone number. If somebody feels that they have a case that warrants attention, is that the right place for them to reach you?
Yeah, if it's in Ventura County, yeah. Yeah, I'm sorry I interrupted you, but we're thinking the same thing. Yeah, if the allegations involve, we have venue, then yeah, you absolutely contact me.
Wonderful. Well, thank you for joining us. We're going to go on and talk about another couple of cases. I'm not sure if you're able to stay. I see there's a couple of items in the Q&A tab, so let me see what they say before I let you go. So, okay, so are you able to open up the Q&A tab, Dominic? Because maybe you could take a look and see if
I am.
that triggers something that you may want to respond to.
I'm reviewing the questions now.
Great, thank you.
Huh?
So we'll give Dominic just a minute or so to look at the questions. Thank you, Anne, and thank you, Vit. We appreciate you writing in, and we'll see if these are things that Dominic thinks he will have the ability to respond to. And I see one of the questions has to do with my company and our purchase agreement, so I'm going to look at that too. And so, Tom, if you have anything to say, go ahead. We're gonna just look at these questions for just a moment.
Sure, and I see there's another question about federal cross jurisdiction as well, which is interesting. And I'll leave that to Dominic. I don't know the answer there.
Well, if we have a case that warrants, we would refer it to the Southern District. If the question is, do we work on cases together? Typically, no. They're gonna stay in our Superior Court, or if the losses are so significant where it warrants federal prosecution, they would refer the matter down to. We have sent a couple cases that were substantial down to Los Angeles to the U.S. Attorney's Office. So hopefully that answers Gretchen's question. We don't prosecute them together. Okay. And then with respect to the recorder, the Ventura County Recorder does not they don't send notices out with every single document that's recorded. So it's really on the homeowner, my understanding, to be diligent. They do, when a notice of default is recorded, there is a list of resources that's sent to the owner of record to assist them, but I'm not aware that our recorders sending out notices on every document that is recorded.
Okay, well, great. This has been really good stuff, and it's nice to know that our audience is listening and paying attention. So thanks a lot. We really appreciate your time, Dominic. And if you want to stick around and see if somebody else writes something in, you're welcome to interrupt at any time. And if you have to go, we'll understand.
Okay, I'll stay on. Thanks, Neil.
Okay, great. So let's go on to our next case. In Ray Hawkeye Entertainment, right? And this is a bankruptcy case, but it involves, leased property, so it involves real estate. So I thought it might be of interest for our listening audience today. And here we have a case here. We got these downtown LA cases, Tom. So you probably know what's going on around here a lot better than I do. Smart Capital leased several floors of a commercial building in downtown LA. So Smart Capital was the landlord, leased to Hawkeye, that was the tenant, to use as a dance club. It was recognized that the lease was significantly under market, and Smart Capital acknowledged that apparently in the courts, because that was reflected in the appellate opinion. Hawkeye would not sign estoppels when requested. Smart, of course, wanted to get out of this, unfavorable lease to Smart, and attempted to terminate for several and alleged non-monetary breaches by Hawkeye. Hawkeye presumably, reached out to counsel, filed for Chapter 11, and then sought to assume the lease and prevent eviction under, and I'm assuming those who practice this area know Section 367B1 more than I certainly would. In April of 2020, when there was the eviction moratorium in LA, Hawkeye moved to defer April rent. It turns out they paid that rent into a trust, not to their landlord. but later wound up paying the whole thing to the landlord in full plus a late fee when a court ruled the moratorium did not apply. Okay, so Hawkeye wanted to assume the lease as part of the bankruptcy process. The bankruptcy decision, the bankruptcy court and the trial court were in sync with their findings, that the alleged breaches by Smart was basically kind of making things up, trying to find a pretext to get rid of Hawkeye, and they permitted Hawkeye to assume the lease. Went from bankruptcy court to the district court. Smart appealed to the appellate court. The appellate court said, well, what does section 365B1 require? It requires the debtor in possession to provide adequate assurance of future performance. And here was kind of the quoted language, where there has been a default. And the federal court said, well, we need to look to state law to figure out whether there was a default. Certainly there was no active default, because the only monetary default, at least, had to do with the rent, which was eventually paid with the late fee. Okay. So the appellate court looked and said, what does this language mean where there has been a default? So they said, we're going to look to state law to figure out what a default means, but we also have to look at this language that says where there has been. So they're saying, I'd have to go back to grammar lessons. I don't know, it's like past perfect or past imperfect or something like that. But it says where there has been, not where there currently is a default. So the appellate court said, well, okay, the lower court said, there's no current default, that's what matters. The appellate court said, no, that's not what matters. What matters was whether there has been a default, and there was a default in the past. So we need to consider that. And now, what is a default? We're going to look to state law, and default does not necessarily mean that there's been a material default, but there's been some kind of failure to perform. So what did the court say? Well, because Hawkeye says we're going to assume the lease, right? There was essentially three things that needed to be done, right? You had to cure, you had to make up for any damages, and basically you had to have some kind of promise or statement that there's not going to be defaults going forward. The first two were not really the issue here. And the court said, well, when Hawkeye agreed to assume the lease, what they're saying is we're going to take responsibility going forward for these lease terms. So that provides assurance of future performance. Is there anything done? Should this have been applied? What did the court ultimately come down to? And said, well, even if we say there was a failure to assure future performance, it doesn't matter, right? It's harmless error, and that goes back to what I said. It's harmless error because by assuming the lease, Hawkeye is saying we're going to perform in the future. And my last sentence here on the screen basically says the court was kind of looking through all of these legal arguments, right? The court's looking through these legal arguments and saying, you know what? Guess what, Smart? You can't use the bankruptcy laws here, even though they were initiated by Hawkeye. You can't use them to get out of a bad deal that you made. And that was kind of the bottom line. The court was looking at the bottom line. Tom, you're kind of nodding your head. I'm sure you have something much more relevant to say than I do.
Well, no, I think you hit on most of the points, Neil, but did you catch, how the trial court, reading this decision, boy, that trial judge did not like the landlord, did they? The trial judge mentioned that the landlord was overcoached.
Right.
Was disingenuous. The landlord just a couple months prior to serving the notice of default under these non-economic defaults was telling banks that the tenant is not in default. So the trial court was critical of the landlord and questioned, as you said, the motives behind it. Really was just to rent that space out for a higher rate. But I thought that was intriguing. And these defaults, we're talking about these non-economic defaults. It was stuff like hanging banners outside, subleasing to a church. Not cleaning graffiti, I guess hosting all age events. And what the Court of Appeal, interestingly, I thought it was intriguing because the Court of Appeal said sort of set a very low bar for establishing further assurances on non-economic violations like this. The Court of Appeal basically said, look, what else do you want other than a representation from the tenant that they're not going to do those things anymore? There's nothing else the tenant can do. So the bar is extremely low when you've got like those sorts of trivial and, in from a landlord's perspective, not trivial, but those sorts of violations. I thought the trial court got it completely wrong about what constitutes a default, and so it was good to see the appellate court confirm what everybody understands is that a default does not a default is governed by the terms of the actual lease. The lease defines a default, and if you violate the terms of the lease and fall within that definition of default, there's not some standard of materiality that is, implied in that. And so I thought that was important as well to discern from the appellate decision here. So an interesting case, coming out of the bankruptcy court on a downtown property. And so I've driven by that location. I'm familiar with the building. You probably are, Neil, but haven't been to the club, haven't been to Hawkeye. So, no personal knowledge there.
Great comments, Tom. This is why I know and when Ashley would join me, we always love to have a litigator join us to bring that different perspective. And I think part of, what comes out here is you got to remember, judges, justices, if you're talking about, state court, they're people too, and they're going to be able to kind of look and see what's really going on. And certainly as a litigator, you're going to have to take that into account when you're advising the client on their prospects of success. So let's move on to our last case. Not going to go through the whole case. The kind of case I hate. I think it was 45 pages long. The good thing about a case that's 45 pages long is it goes into a lot of detail, goes into a lot of history. I mean, here we have the case. Today's for basically the Westin Bonaventure Hotel was contesting, an extension of the subway line, saying it's interfering with our use. They tried to challenge it, originally lost. One of their challenges was, the contractor could have used like a tunneling method instead of the method that they particularly used, which was kind of an open dig. And the court said, they did what they did was reasonable. Essentially, what they did is reasonable under the circumstances. So the challenge to the dig itself was unsuccessful. But then Westin brought another case saying, well, it's the way they went about it that was bad. And they did things specifically to get back at us because we challenged the subway going in the first place. And they did construction at night, and we're a hotel and we have guests, and guests sleep at night, and if guests are being disturbed, we're gonna lose business. And we have activities at night that you just don't have in the surrounding area, which is mostly office space. And so by taking these actions, contractor, you were really targeting us as a business, as a hotel. And you know what? They didn't get too far with that argument. And again, I'm not going to go into all the details, but particularly if you look at the nuisance part of the case, the court is saying nuisance is a balancing test, and you've got to balance the interest of the property owner that needs to have an expectation that there's going to be some interference when you're in a urban environment versus the interest of the community at large, which is that's being served by having a subway extension. So I thought that was an interesting kind of discussion. Again, long case, worthy discussion. Tom, what do you have to say about today's four?
It is a super long case and it's very detailed, but ultimately this comes down to gatekeeping, right? When you look at the decision and balancing the test in favor of the, MTA, as well as upholding the statutory immunity, this is really all about gatekeeping, because at the end of the day, how are you going to get public works accomplished if that case could go forward? So I think it's a very important decision, and the court is really making a value judgment about the importance of being able to conduct public works in this sort of a location without having significant legal exposure every time you want to accomplish anything for the good of society. So interesting case, and I thought I thought the decision fell on the right side too.
I think I agree with you on that one, Tom. And how are you going to get anything done? As it is, it takes years or sometimes decades to get something done. And if any individual entity or property owner can put a further cog in that, you're right. Nothing will ever get built in an urban environment. It will just be, it's hard enough as it is right now, and it would be near impossible with the claims that were raised by today's four and the West End. And Dominic, I see you're back with us. Do you have something that you wanted to point out?
I just wanted, thank you. I just wanted to respond to Vit's question and Robert's comment about the LA County Recorder sending notices. During your presentation on the third case, I called our recorder's office and confirmed we are not sending out notices. The LA County Recorder collects a fee under Government Code 27387 to pay for that outside vendor that sends those notices. What our local recorder is doing on quitclaim deeds, since quitclaim deeds from prior experience are typically used to commence a fraud, to get on title, they are flagging quitclaim deeds in Ventura County, and they do notify. So I stand corrected from my comments earlier. The homeowner does get notified on a quitclaim deed, and that's something our local recorder is doing preemptively without collecting a fee. So hopefully that answers the question.
Well, first of all, we appreciate the fact that you were taking the time to do that. So that's great, Dominic. And I'm just going to mention the first question that came in that was from Ann. And Ann was really pointing out that there's title insurance policies. So if you're a real property lawyer and your client is having trouble, maybe the first call is to their title insurer to say, is this a covered event? Is this an insured event? And one would have to look at the policy. If it's a home, if it's a residence, maybe they have something called the homeowner's policy of title insurance, which is really a very broad-based coverage, much more than one would get from the standard CLTA standard coverage policy. So thanks, Ann. That's great advice. And you mentioned, in your second comment, that it's more than just a fraud claim that would be necessary. There would have to be a forgery, but that's a title insurance issue, and that's certainly a great place for lawyers to start to see if they can try to get some, compensation back for a client who's been taken advantage of. So thank you there. You know what? We got a few minutes left, so let's go. What's coming up with the RPLS? And you see, we've got a couple of webinars. Not a lot going on at the end of the year. One in November, one in January. There's some other things I put on the screen, something from Solo Small Firm and something from the litigation section that I thought our members might want to be interested in. If you want to contact us, there's all the ways to contact us at RPLS. And we got about 5 minutes left. You know, Tom, and earlier in the month was the Crocker Commercial Symposium, and you were one of the coordinators of that event. So why don't you tell us about it and what happened, and whether you're gonna, not you personally, but whether Crocker's gonna go forward next year.
Sure. No, thanks, Neil. I appreciate highlighting Crocker. It's been a 4-year partnership now with the LA County Bar Association. So we started the Crocker reconstituted as a mini symposium, 3-panel format, starting back in 2019, pre-COVID. And it's been a successful run. LA County, great synergies between CLA and LA County Bar. And it's basically a real estate mini symposium with panels that focus on 3 separate real estate disciplines: leasing, development, and finance. And so this year we had about 150 people in attendance. We were virtual this year. Next year, we're planning on going live, physical or hybrid. It was terrific. We had great speakers. We usually get a combination of lawyers who are experts in the particular fields that are local to Los Angeles, greater Los Angeles area, as well as people in real estate business persons in real estate development, in banking, finance, and in public service as well. So we had a panel on the finance side. There was a panel that discussed ESG and the rise in ESG and in real estate investing and lending. We had a panel on the challenges of housing and kind of the NIMBY versus YIMBY dynamic that's happening. Reviewed a lot of recent trial level decisions on housing issues in LA. And we had a panel talking about the different commercial leasing trends that are happening that are a result of COVID. And so great content, and we expect to be doing another Crocker next year, and it's been a terrific and successful partnership. So we hope to get as many members of CLA and LA County Bar, and for that matter, we've got attendees from out of state, other parts of the country that have heard about it, the program, and are attending remotely. So we hope to get increased attendance and welcome anybody who's interested in joining. Keep a lookout for notifications. It's typically in the fall every year, and great event. So hope to see everybody there.
So Tom, I'm going to give two plugs. One, I think you really understated the quality of your speakers. I mean, I've been to several of them. I've listened to 2 of them online, and you get people who really have expertise and know what they're talking about. That's one. Second thing is, even though it's a partnership with CLA and LA County Bar, as anyone who's listening can hear, the topics go beyond Los Angeles County, right? The topics are applicable no matter where one practices real estate law in California. So those who are thinking about it for next year, or maybe want to, visit the CLA website and think, oh no, that's LA. I don't live in LA. It doesn't matter. No, these topics are going to be applicable to you no matter where you practice real estate law in California. And I see it's 2 o'clock, so I'm just going to throw in one quick plug for next year's Real Property Section Health and Wellness Retreat, March 23rd to the 25th at the Fairmont Hotel. It's more than a hotel. It's really, it's a whole inn, whole spa area there in Sonoma County. So mark your calendars now. I want to thank everybody for joining us. I want to thank those of you who wrote in questions, and I particularly want to thank Dominic Cardam for joining us and being our special guest today. Good afternoon, everybody.
Thank you. Take care.
Take care, everyone.
Thank you.